Hi, everyone. This is Gene Richards, attorney from the Williams Law Group, back on the Navigating DCPP podcast, the podcast where we break down complex issues involving the division of child protection and permanency. On today's episode, we're going to discuss why some kids don't go home. The unfortunate reality of DCPP cases is that removals from a family's home does happen, and there are instances, although a small percentage, where those children unfortunately never return home. And so I want to discuss with you today why that happens and perhaps discuss ways to prevent that from happening. A friendly reminder for all of you listening that any information I share on this podcast does not create an attorney-client relationship, but our office does welcome any person involved with DCPP to contact for a confidential consultation with our team. So I mentioned the topic for today's podcast where it says that what we're discussing, some kids don't go home. And, well, we discussed in prior episodes the idea of permanency and that DCPP must provide the court with a permanency plan that can involve reunification, going back home, that can involve as severe as TPR, termination of parental rights, where the rights of the parent or parents are terminated. And you might think, well, what does that mean? Well, it means what it says, right? When the division attempts to terminate parental rights, DCPP is trying to sever that legal right a parent has towards their child. That means no legal custody, no physical custody, no right to make decisions for education, medical, and so forth. It even includes the idea of having no contact whatsoever. At that point, if your rights are severed, you as the parent really are no longer the parent and therefore have no right to visit that child who's been or at some point adopted, because once you have the termination of parental rights, the next step is to have that child be adopted by somebody to provide permanency and stability. Because as you might imagine, we know DCPP stands for the Division of Child Protection and Permanency. So there's really two fold of goals here, or two parts of the equation where DCPP needs to provide protection. We can discuss that later on, but and also permanency, which means that DCPP's goal is to provide stability and permanency for a child. And sometimes that may include the TPR trial or termination of parental rights trial. So what are the grounds for termination? Let me just discuss first, there are some factors that the court must consider and look at when determining whether or not to terminate a parental rights of the parents. And so first of all, the division has to initiate that petition to terminate parental rights, and it's based on what they consider to be the best interest of the child. Basically, DCPP is saying that it's in the best interest of the child or children that the parental rights be terminated. The factors that the court must consider when this occurs is the child's safety, health, or development has been or will continue to be endangered by the parental relationship. So in the past and then, or perhaps in the future, if that parent retains their rights, will that child's safety, health, or development be in danger, or was it already in danger? The second prong or factor the court must consider is the parent unwilling or unable to eliminate the harm that faces the child, or is that parent unable or unwilling to provide a safe and stable home for the child? And the delay of permanent placement will then add to that harm. So can the parent address the issue, address the allegation, whether it be substance abuse or a mental health concern or delusional disorder? And if that parent is unwilling or unable to do so, then will that delay in permanency end up causing more harm to the child? The third prong or factor the court must consider is, has DCPP made a reasonable effort to provide services to help that parent correct the circumstances which led to the child's placement outside of the home? And the court has to also consider alternatives to determination of parental rights. So has DCPP provided the parent with evaluations or screens or therapy or treatment to help that parent overcome what led to that child being placed out of the home? And the court must also consider, are there other permanency plans that may be a better fit, like KLG? Or perhaps reunification is what is best for this child. And so the court must still consider those and know that there are options as well. And then the last prong the court must consider, termination of parental rights will not do more harm than good. So it basically is saying that in terminating parental rights, will that actually cause more harm to the child than it would good, right? Because the goal is the best interest of the child. And so if the parent losing their rights is going to cause more harm than good, then it shouldn't be done. Now, as you might imagine, that sever of the parent and child relationship may always cause some harm, but it's the idea, does it cause more harm than good? So just saying, hey, this will hurt my child and he or she will be very sad and therefore it is not a good thing. Although that may be true, it may not be good to have that contact severed and that relationship severed. And it may cause some harm, but does it cause more harm than good? So those are the factors the court has to consider once DCPP initiates a termination of parental rights petition, which leads to a TPR trial. But what are some of the grounds for termination that DCPP, why does DCPP file in the first place? Well, a number of reasons and grounds DCPP may take action to terminate parental rights. It may be chronic abuse or neglect. A parent who has repeated patterns that show the parent cannot keep the child safe. Maybe numerous removals. I've had cases where a child was in and out of the parental home, the family home, 3, 4, 5 times. So this parent was constantly involved with DCP, and in very severe cases to the point where a child's removed 3, 4, 5 multiple times. And so that pattern of abuse may be a grounds for termination, or at least a petition to do so. Severe or repeated physical or sexual abuse. Situations where the child's well-being is at high risk, right? These things keep happening again and again. They're very serious. Much harm was done to a child. And at that point, right, if there's ample evidence to suggest that that child ever returning home is not going to be in that child's best interest, well, again, grounds for potential termination of parental rights. Long-term mental illness or substance use that prevents parenting. Now, not just a diagnosis, but being unable to care for the child. So I'll tell you what I mean by that. I've had cases where a parent was diagnosed with something, schizophrenia, disorder, things that are very tough to deal with and very difficult to parent through. And as you might imagine, and I certainly argued, that diagnosis itself does not prevent a parent from parenting. Many parents have diagnoses and have kids in their care without DCPP being involved. And that's true. It's make you an unfit parent just by being diagnosed with a mental health illness or a substance use issue. The issue is if it's not being addressed, right? That person's not taking medication they were prescribed to take. That person's not in services and therapy and counseling, seeing a psychiatrist. That person's not in treatment for substance abuse. And so the issue isn't just, oh, I've been diagnosed. The issue is being diagnosed and then not addressing it. And then by not addressing it, you're now putting your child at risk of harm or maybe harming your child. Another grounds for termination would be failure to maintain contact or support. So when a parent consistently does not visit, call, or provide financial support. It leads on to really my next point, which is abandonment, right? You have a child who you leave without communicating with, plans for care, nothing. You literally abandon that child. I had a case where a client of mine who retained years after this actually happened, but she had dropped off a child, the father's home actually, really without communication, without plans for care, just kind of left abruptly, and there was no plan in place. And so because of that, division found her to be abusive and substantiated her and then terminated her rights. And that was many years ago, but leaving your child and not caring for them or communicating with them or having a plan for their care, abandonment, that can lead to ultimately your rights being terminated. Criminal history, particularly if it involves violence or child endangerment or results in long-term incarceration, right? If you have that time where you're incarcerated for many years or for life, that may be grounds and reasons for having your rights terminated. If you can't parent or you won't be able to do so, DCP may say, well, we know your rights shouldn't be here then. We should terminate them and have your child placed somewhere, adopted somewhere for stability and permanency. And so those are different grounds for termination. I do want to discuss, I already kind of sprinkled in some personal stories there, give you an idea as to the issues with TPR. Fortunately, there have been a lot less TPR trials or cases as of late. I do believe that with a new case law and just protocol, that there have been less petitions filed. It's been much more difficult for DCPP to actually terminate parental rights, which is a good thing. I mean, parents' rights, once they're severed, you can appeal it and hopefully win that appeal, but once they're severed, that's it, right? The child, the children that you were raising, that you birthed or helped birth, and it's a big deal to have those parental rights. And so it shouldn't be so easily obtained by the court or by DCP. That's a positive thing, but there are so many flaws. And one of the biggest flaws is that obviously, as you might remember from other episodes, that the permanency, within the first year of removal, DCPP is supposed to provide the court with a permanency plan, one of them which could be TPR. And unfortunately, I find that DCPP can oftentimes drag their feet, delay services, delay referrals, almost set a family or a parent up for failure, right? Because as each day and week and month goes by, you're closer to that permanency hearing and closer to the a time where DCPP can then formally petition the court to terminate your rights. And so with workers and DCPP being overworked, as are most people these days, it seems, a lot of times, whether it's an excuse or not, it's what's said oftentimes, that can lead to apparent services that are needed to perhaps rectify an issue not be addressed or addressed in time to prevent that permanency plan of TPR or that TPR trial being scheduled down the road. And so that's a huge flaw because time is of the essence. And oftentimes when dealing with a state agency, time isn't of the essence for them. Government takes a while for many things, and that includes DCPP and then making referrals, them having evaluations. And I'll tell you what I mean, right? Say a parent has severe mental health or psychiatric issues, and DCPP first will want to have that parent evaluated. Okay, so say you agree to it right away. They make a referral. That doctor is so busy and can't see you until 45 days from the referral being made. So you're already a month and a half into the case, 2 months into the case, and you come for the first appointment and you had the appointment and it was fine, but it's not over. There's still more time to be done for interviews, evaluations, or it's a second appointment. So you come back 30 days later. Okay, now you're at month 2 or 3. Okay, evaluation's now done. You wait 2 months for a report. You're at month 4 or 5 already. And it comes back with recommendations. It says, parents should do this, and this, and that service. And so you have 4 more things to do from the evaluation. DCP makes referrals for a therapist and for treatment and things like that. And that's then made at month 6 or 7. By the time they have room for you to fit into their schedule with the different experts and doctors and therapists, you're at month 8 and 9. And here you are, you're 9 months in, and there really hasn't been a start of any services that may address the underlying issues. And so it's important to really be proactive in, one, getting your own services if you need to, right? I mean, that's why I always say you want to defend yourself and push back, but you also have to kind of pick your battles. I mean, look, if there are concerns and they're legitimate, you got to address them. Just denying everything when some things can be true. DCPP isn't always wrong. The referrals aren't always completely false, right? So if you're not addressing the issues and just saying no, 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 and before you know it, you're a year in and nothing has been done to move yourself towards reunification, not a good look for the court or for yourself. And so it's important to be proactive. Get your own services. Get your own evaluation. Right? Because how can we, as an office, as counsel for you, or even as yourself as the parent, put yourself in the best position as possible to have your child or children back in your care? Maybe seek your own expert. Get an evaluation where someone, when you pay them the money yourself, they might get things done faster. Get in that expert evaluation before the first month is done. Get a report before month 2 is done. Have recommendations or it'd be nothing. And say, look, I told you I'm fine. Here's what the expert said about me. I no recommendations for services. I'm good. So that's a big deal. Being proactive yourself by getting services, evaluations, and getting those things done ahead of time or as fast as possible. Another way to kind of beat the system here is to really be on top of DCPP, whether it be their attorney, caseworker, their supervisor. Really say, is the referral made? When is it? If there is a time where an appointment opens up, I'll be available. It's just like the doctor, the dentist, or somebody like that, right? If you say, hey, well, we have you down for 6 months from now, you might say, well, I want to come in earlier. If someone can't, just can I come in and give me a call? And same thing for the evaluations. You tell the DCPP, the worker, or have your attorney tell their attorney, hey, if there's an opening, I'll be ready to go. That's a way to get in faster. You might be able to get in a month faster by doing that. If someone cancels, someone doesn't show up, they call you and you go and you get it done. So you got to be proactive and really be on top of DCPP. I sometimes tell clients, it's like we do their job for them almost. And what I mean by that is if they need collateral, if they need information, they need something done, let's get it done for them if we can. Send them records. Call the place you're getting an evaluation. Say, can I come in now? Are you available? What's going on next? Got to come in again. Right? Really be on top of that so that, I'll tell you what I mean by that because, right, you have one case, your case. The worker has 50 plus cases, I don't know, many cases, at least 50 or more cases and families to deal with. And so you have more time to invest in your case than that worker does. So you be proactive and reach out, call the caseworker, ask, has a referral been made? When do I go? Where do I go? Just be a participant, be engaged. And by doing that, you can help really push the case faster and services faster and get these things done prior to there even being perhaps a request to terminate your parental rights. I do, as always, want to just thank you all for listening. I know it's a very tough subject to hear sometimes, emotional for people who've been through DCPP cases or experienced even perhaps TPR cases or TPR trials. So just remember that it's important to be really proactive in trying to prevent a TPR trial from even being started, right? And really get services done proactively, reach out to DCPP and get things done as fast as possible, and understand the grounds DCPP files a petition for, and also why, what the prongs are when it comes to the court and what they consider in TPR trials. Because if you could address the grounds for that petition in general, not doing those things, or perhaps address the prongs and make sure the division can't prove that case in court, those are ways to prevent the TPR from being granted. Because once it's granted, you can appeal it, but once that's severed, that child-parental relationship, it's gone. Unless you appeal it and win it, and by that point, it might be a remand and still might not come back. But either way, this is a big deal. This is really the most serious part of a DCPP case, right? We're talking about a parent losing their rights. So if anybody has anything on their mind, questions or things like that as you kind of think about this or along throughout the week or throughout the months or whenever you listen to it in the future, it's important to look at resources we have on our website, life after TPR or before TPR, and how to prevent that, and just reach out for assistance if you need it. As always, if you want to subscribe to our channel and share it to your friends and family so they can also understand what DCPP is about, how they operate, and what it means to be part of a DCPP case, because it really is difficult to navigate DCPP cases. I mean, they take a million different paths, and no case is alike, whether it seems that way or not. No case is really ever alike. And so it's important to know, because if you don't know, when you find yourself in that position, it's even scarier than it would be if you do know. So just please, share, like, subscribe, and make sure that people just have knowledge of what it means to be in DCPP cases and how serious they truly are, because they can lead to a TPR trial where parental rights really are severed for good. So until then, stay safe, and I'll talk to you next time.